and thank you for being here. As you all know, just under 3 hours ago, the United States Supreme Court came down with a landmark decision. A landmark decision that upheld the Federal Affordable Care Act. Well, it's always been my viewpoint that attorneys general, especially the Attorney General in Wisconsin, should not be active in policy debate and using litigation to expand or enact policy provisions that the Attorney General or others may have, that it is our job to protect the state's legal rights and to make sure that that necessary tension between federal government and state government and other balances of powers are maintained. It was very clear to me that we needed to read the legislation in its entirety and to determine whether there was a legal basis to sue the federal government, not a policy basis to do so. It was very evident to me early on that there was not only a legal basis, but there was a legal necessity to do so, along ideological lines. The reality is that the Obama administration, the President and Congress, passed a health care act mandating that individuals buy insurance. They justified that under an expanded use of the United States Commerce Clause. They continually and repeatedly denied that it was a tax. Today, the Supreme Court has found that it was not an appropriate use or expansion of the Commerce Clause, and it indeed, despite what the administration said, was a tax. And it is on that basis that they upheld the law. We, as Wisconsinites, got involved as litigants in this case specifically because an expansion of the Commerce Clause under the United States Constitution to allow the federal government to mandate that individuals buy something as a justification for controlling and regulating interstate commerce was beyond their constitutional authority. And if it was beyond their constitutional authority, then of course they were invading what was reserved by our founding fathers in the United States Constitution for the states to use in self-governing. It was a violation of one of the most important principles in our country's history, and that is federalism. The Supreme Court has upheld that legal argument of ours and has protected federalism and the rights of states to sovereignly govern in areas that were reserved for them. That it was a bait and switch under the Medicaid program, and that the federal government was illegally and unconstitutionally using the spending clause to coerce states into implementing Medicaid expansion by virtue of threatening to take away all other funding that they have previously given us for Medicaid if we did not implement the program. It was our opinion that under the law that clearly had reached the level of coercion, and it was time for our United States Supreme Court to take a position and say, this is beyond the spending authority of the federal government and the Constitution. I am pleased that today, on the second of two legal claims that we brought, we have prevailed. Yeah, well, from a policy perspective, I don't give advice to the governor, I don't give advice to the legislature. From a policy perspective, it's going to be up to our elected leaders in the legislature and the governor's office to determine whether we do want to expand Medicaid and what we want to do with regards to implementing the Federal Health Care Act here in Wisconsin. There are certain provisions that, of course, it's going to be necessary under the law for them to enact and move forward on. The one where they're going to maintain some discretion is the Medicaid expansion, and that's going to be a public policy decision that's going to be up to them to make.